Good evening to all of you. I have great pleasure in welcoming all of you to this Global Legal Practitioners Colloquium. My name is Raj Kumar. I am the founding Vice Chancellor of OP Jindal Global University. It is indeed my proud privilege to welcome our very distinguished guests, whom I will introduce very shortly. I would also like to extend a warm welcome to all of you to this webinar on the legal profession in the age of COVID-19, the future of litigation and law firms. COVID-19 is no more just a health crisis. While human lives may be the highest price paid, the world is now spiraling into a state of economic and humanitarian crisis. Unequal access to healthcare, reverse migration, xenophobia, domestic violence, racism, job losses, migrant workers crisis are some of the many side effects of this pandemic. In times of this chaos, the legal and judicial systems play a very important role in avoiding the ill effects of the pandemic from reaching apocalyptic dimensions. To protect and even strengthen our legal and constitutional rights, while we are to some extent being asked to temporarily suspend them in some cases due to the required measures of lockdown, making the role of courts, litigation, and even law firms more complex in the current context. Not only are we faced with a broader demand of justice, but also faced with the challenge of operationalizing justice in the times of quarantine, lockdown, and indeed gradual unlocking of our society. Even law firms have reinvented the machinery to work from home using technology. While the very esteemed three-judge bench, which recently issued guidelines to transition to virtual courtrooms, the Indian legal system is indeed witnessing a revolution of sorts. But this is obviously very limiting, with little or no impact at the lower levels of justice delivery mechanisms. Therefore, this colloquium is an important platform to seek a response to some important questions to define the future of litigation and law firms from the leading legal minds of India and beyond. I have great pleasure in introducing my guests. Ms. R.V. Anuradha is a partner at Claris Law Associates. Prior to this, she was a partner at Amachan Mangaldas. Her focus areas include trade law and policy, environmental law, carbon financing, and climate change. Her work relates to both transactional practice as well as policy advisory work. She is one among two lawyers from India, recognized by the International Who's Who of Trade and Customs Lawyers for 2009. Anuradha graduated from the National Law School of India, University, Bangalore. She has a master's degree from the University of London, where her focus was on law and development and international environmental law, and from the New York University School of Law, where her focus was on international economic law. Welcome, Anu.
Thank you.
Ms. Purvi Chotani is the founder and managing director of LawQuest, an immigration and employment law firm headquartered in Mumbai, and the law office of Purvi Chotani PLLC in Florida. Purvi heads the global immigration practice at both these firms. She is an alumna of Penn Law School, is admitted to the New York State Bar, and is a registered and practicing solicitor in England and Wales. Purvi has been consistently nominated amongst the world's leading immigration private practice lawyers in Who's Who Legal each year since 2009. Purvi was one of the 101 women lawyers from all over the world who relayed her success story in the American Bar Association's prestigious publication, quote, The Road to Independence, 101 Women's Journeys to Starting Their Own Law Firms, unquote. She's also been listed amongst one of the top 100 most powerful women in law in India. Welcome, Purvi. Mr. Shyam Divan, he was a senior advocate of the Supreme Court of India, working primarily on civil litigation across banking, securities law, arbitration, administrative law, and environmental law. He often represents citizens group in several environmental cases and is currently also assisting the Supreme Court as an amicus curiae in the Bellary case involving illegal iron ore mining in Karnataka. He is a member of the Executive Committee of Law Asia and co-chair of the Law Asia Human Rights Section. He is also an executive committee member of the Bar Association of India and part of the Board of Consumer Education and Research Center in Ahmedabad and chairman of the managing committee of the Indian School. Thank you, Shyam, for joining us. Mr. Arvind Nair is a senior advocate and arbitrator at courts and tribunals in Delhi with a focus on company law and banking practices and labor and service laws. Arvind was designated as senior advocate by the High Court of Delhi in 2017, and his practice spans appearances in the Supreme Court of India, the High Court of Delhi, and the various commercial tribunals situated in Delhi. He appears in a variety of practice areas, including banking, company law, insolvency, service matters, and competition law. Arvind also appears and conducts ad hoc and institutional arbitrations as an arbitrator. He has represented clients in proceedings in court seeking interim relief, the appointment of an arbitrator, and challenges to arbitral awards. Most importantly, Arvind and I were classmates at Campus Law Center, Faculty of Law, Delhi University. Thank you, Arvind, for joining us.
Thank you, Raj. Thank you.
Mr. Ritin Rai, a senior advocate of the Supreme Court of India. Ritin is a graduate of Campus Law Center, Delhi University. He went on to complete a BCL from the Oxford University and a LLM from Harvard Law School. He began his career at international law firm Jones Day, where he spent 2 years. He then worked at Pathak and Associates for 3 years before setting up his independent practice in Delhi. Ritin has expertise in commercial and regulatory disputes in all areas, including telecom, company law, insolvency, and competition law. Ritin is the first international lawyer to be inducted into 7 King's Bench Walk. He joins a small but significant group of Indian lawyers associated with a set of barristers' chambers in London. Thank you, Ritin, for joining us.
Thank you, Raj.
All right, let's begin this. My first question is to Shyam Dhiman. Shyam, the very foundation of a nation's response to the current pandemic crisis is the law. What are your views on the effectiveness of the Epidemic Diseases Act and also the Disaster Management Act? I would like to keep it at a more general level, but we can go into more details later. Would it help to have a more customized set of laws and regulations, such as the UK's Coronavirus Act or the Singapore's Infectious Diseases Regulations? What can we imbibe from these experiences of other countries to embrace ourselves for a more robust response to dealing with such crisis in the future? Shyam.
Well, my response would be that, look, in India, I think the government would, as you indicate, have had a choice of between bringing in specific fresh legislation or possibly using something which was already there on the statute book. Now, the advantage in India of using something which is on the statute book is that you don't have a flurry of challenges to the new law or the new ordinance. And I think that's a big plus. If you have something like the Disaster Management Act, which is already on the statute book for, a decade and a half, and you have an Epidemics Act, and you feel that the language of that statute is wide enough to support the broad purpose of your executive actions over the next 6, 8, 12 weeks, then I think you will probably find that most courts and most citizens would support you, even though those statutes may not be exactly tailored for a global pandemic of this sort. So I think there's a wide berth which both the citizenry and courts would extend to the executive in a situation such as this. And therefore, I think, considering that you didn't have parliament and you do not have parliament in session, the choice between an ordinance versus using something which is existing, which has broad language, was, I think, a call which the government was required to make. And I think this is a probably reasonable call, having seen the statutes and the few amendments that they brought in. That said, I think there are several advantages in bringing about a new statute. Obviously, there are concerns now, contemporary concerns, which may not have been addressed earlier by the earlier laws. One of those concerns which strikes one is privacy concerns. The second concern is, how long is this going to continue? So do we require a sunset provision? Had we a new law, I think we would have had some sort of a horizon. We would have had a sunset provision. We would have had specific provisions with regard to targeted aspects regarding protecting privacy, which is creating a large amount of problems. And you're also finding that you have situations where I think in their enthusiasm, governments are probably extending themselves in the form of overreach. For example, you have what I find problematic is you have certain directives which are going in respect of free speech and the dissemination of information using provisions under these statutes. But I think on a case-by-case basis, we have a fairly robust system which can correct any excess which takes place. So personally, while a new statute would be probably, which is tailor-made, would be probably ideal, I don't think there is broadly anything very wrong in relying on both the Disaster Management Act as well as the Epidemics Act, despite their vintage.
Thank you so much, Shyam. Maybe I should move to Anuradha. Anu, one of the things that we have realized during this phase is that a large part of our community, in the sense of people across India, have been plagued by disruptions born out of COVID, such as larger, aspects of unemployment, the migrant crisis, which was very visible, cyber frauds, including some of the latter effects of domestic violence. Now, how important do you think it is for us to prioritize the legal profession as an essential service during the pandemic? How do you imagine, this impacting the legal profession? Because we know that the medical profession clearly and most obviously is part of the essential services. Should legal services be essential services as well?
I guess there's no easy answer to that, Raj, because in a sense, as far as the transactional advisory part of lawyering is concerned, as Purvi had mentioned this before, we started, it's kind of been a seamless space of working. But the questions that you have raised is really where it impinges on right and liberty. Domestic violence is a case that you cited, but so are a variety of concerns ranging from not just privacy, but also in terms of questionable arrests and the urgency for bail applications, etc. And while courts have stepped in to provide for having also transition through technology to provide for hearings for what they may consider as essential matters, I think this is an area which certainly requires a lot more work for ensuring accessibility, for ensuring clarity. So this is, I guess there's no easy answer to say whether entirety of legal services should be declared as essential. But I think certainly protection of rights and liberties and the manner in which we were to implement it requires a great more deal of thought and action for.
Thank you very much, Anu.
Any future scenario.
Yeah, thank you very much, Anu. Purvi, let me move to your story, because your story is in some ways very compelling. You're a global lawyer. You practice across multiple jurisdictions. So my question to you is that one of the most important aspects of global lawyering is the need for mobility. People, traveling across different countries, engaging in meetings and, creating opportunities for new deals and things like that from a corporate and transactional law firm standpoint. But somebody like you who has multiple offices in different jurisdictions, particularly in the United States and India, to what extent the COVID-19 crisis has impacted the world of law firm that you are part of?
So our practice is focused on immigration and employment law, and in most countries, all the immigration processes are digitized, including in India. There's a lot of digital element at government level, so it has been extremely seamless. The part where we have to move people around, yes, that has come to a standstill in most countries. And about transactions, we've been able to negotiate, employment contracts across countries, and we've been able to help companies set up operations in the United States, because over there it's very easy to do, all digitally, because you don't need to be in a particular place to sign papers, and you don't need to be in a particular place to submit them to the government portals. So that part has, we've not had any interruption whatsoever. Not only that, investment in technology that allows you to collaborate like this. So our firm has been operating on the cloud for several years now. 4 years ago, we moved to a cloud platform that is also GDPR compliant, because we deal with a lot of personal identifiable sensitive data. And so we were on the GDPR cloud. So our team began working. So they went home one evening, next morning, they were on the platform. We didn't even miss a day's work. Same with the Indian government's immigration situation. The FRROs, that's the Foreigner Regional Registration Offices, seamlessly, no delays. In fact, some of our extensions, approvals and all came in quickly, much quicker than when they are inundated with personal meetings. So I think this is a disruptor. The COVID-19 is such a huge disruptor that we all need to be nimble and move forward with technology very quickly. Countries like the United States have been using technology in the court system for years. We had actually represented a lady in the family court a few years ago from here without ever once going there, because we just didn't need to. We could just call in, present our case, send in our documents, and we won her case. So that's just an example. So it is possible to do, but all the stakeholders have to invest in it. But one challenge that India has is connectivity and access to high-tech technology at the lower levels. That is a challenge because that's even affected our education. Education has gone online, but our domestic workers' children, our drivers' children don't have access to that education because they don't have smartphones. So we have a different challenge.
Thank you very much, Purvi. Let me move to Ritin. Ritin, of course, you also have now become a global lawyer in that sense. But let me take you through the Indian context a bit. Whether it is in some states where labor laws are being eased out to fuel the economic recovery, or the current need for a more stringent Data Protection Act to protect individuals as they migrate into Arogya Setu app, COVID-19 has indeed impacted and highlighted the significance of law, whether it is in healthcare, human rights, or information technology. However, it has also resurfaced some of the cracks and in many ways the limitations within the legal system. So what are some of the most important innovations and renovations required in the Indian legal architecture as we think about the future?
No, I mean, I think maybe let me just start with a note of positivity. I mean, even our courts have already innovated and made some strides even in just the last 2 months. But clearly what this pandemic has shown us is the real need to continue to build and focus on our institutions and our institutional safeguards. So you already asked about the data protection regime. It's been hanging fire for the last 2 years or more. And we've seen the confusion it's caused with this Arogya Setu app, for instance. It was made mandatory first, then it was just a suggestion. The app itself has had problems. There have been cases of false positives. So I think we really need to use this as an opportunity to understand that we need to keep building our institutions and make them more robust. In terms of some of the discussion of repealing the labor laws, I think I personally found that very, very troubling. Even as we saw the entire crisis of laborers and migrants having to move back, and given how inadequate the labor laws have been in protecting them and securing them, to talk of a move to repeal these laws at this kind of time seemed very short term and seemed very problematic. I think it's fair to say the policy has operated very much in a binary fashion, and there hasn't been as much a nuance or consideration as you might want. But in terms of I think the Indian legal system, really this pandemic for courtroom lawyers or disputes lawyers has really just accentuated a lot of the problems that we already knew existed. I think we already had a legal system that was overburdened and delays were a big problem. That's gotten accentuated and in a way now with this pandemic. I mean, we already knew cases were not moving fast enough, and now we've had a bigger problem of cases aren't even getting listed, or enough can't get listed in this new dispensation of virtual hearings. So I think it's really gives us an opportunity though to reform. And frankly, the lawyers are as much part of this reform. We all need to fashion ways of a more effective court hearing, a more time-effective court hearing. And you're starting to see that now with a little bit more of a focus on, let's say, written submissions before the hearing, which expedites the hearing itself. But this is, of course, only, Raj, I think we can speak about it in Delhi and Bombay. But to Purvi's point, there are courts and lawyers who may not have access to this kind of information technology bandwidth. So, but I think one thing that we must think about is that in this time of crisis, we have a real opportunity to reform a lot of reforms that were already pending.
Thank you very much, Ritin. For all the viewers, we are live on Facebook and YouTube, and I hope you will send in the questions very shortly. We'll be taking some of those questions as we move forward in this panel discussion. Let me move to Arvind. Arvind, the suo motu order issued by the Supreme Court of India with guidelines for courts to function through video conferencing marks a very important, let's say, progressive shift in Indian, at least higher court litigation. Video conferencing, evidence recording guidelines, and helpline for technical grievances are some of the current proposed implementations. What challenges do you foresee? What are your views on e-adjudication and technology-led dispute resolution? But then equally important, how will the lower courts, especially the ones in rural parts of India, are going to be impacted? Because we know that nearly 9% of Indian households in particular have internet penetration, including uninterrupted electricity and also even a computer. So with that degree of digital divide, how do we address the access to justice issue that moves from the highest courts to the ones where justice needs to be delivered? Arvind.
Raj, I'll just borrow from what Ritin said, that what has actually happened is that there were these problems that we knew, systemic problems that we all knew that existed. And this has only highlighted that and only accelerated it. So you would know that our Honorable Supreme Court and a lot of our high courts had already, majority of the courts had already moved to being e-courts and online adjudication. But again, as you said, while there is now increased focus on this and there is more acceleration on it, this is something that I think a lot of infrastructure building still needs to be done for this. Because I'll give you the example, and I think it's best to give examples because this is a crisis for which nobody was prepared. In fact, if I were to give a simile, I think it's COVID-19 has turned out to be like either the World War or like the dropping of the atomic bombs in Japan. Nobody was prepared, and there was no, I don't think there was any kind of anticipation that could have worked for this. So while e-courts are there, one issue is the infrastructure for our internet speeds, our web platforms, and our overall publication and our overall ensuring that the outreach to the average lawyer is there. Because we may be able to eventually, we haven't yet caught up, whether it's the Supreme Court or it's the Delhi High Court, we haven't yet caught up with the numbers that we used to deal with when the courts were open, even with the e-courts. An average court in the Delhi High Court, which was functioning as an e-court, was perhaps adjudicating 25 or 30 hearings a day. And today that number is down to 5. But to give you an example, some of the hearings that we have done in the Supreme Court or the High Court, we were using WebEx or some other software. And there have been reports of people having assembled ready for when their submissions at 10:30 in the morning, and their turn only came in at 5 or 6. So those are those structural issues that we'll have to. One is the technological innovation part of it, which we need to. I think there is plenty of scope for that. The other issue is, what do we do in the interiors? What do we do, let's say, in a small town in Bihar or Chhattisgarh or Arunachal? What do we do in a tehsil or a district in Rajasthan? So the other thing is the publicizing. And let's not lose sight of the fact that if we are to eventually move to this method of adjudication all over the country, we'll also have to localize it with the languages. We are not going to be able to have hearings, whether it's on Zoom or on WebEx, in a village in English, or even in a tehsil, or even in some of the high courts in the interiors who take great pride in their own languages. So all of that will have to be done. But I think to take a positive view of this, the fact is that if this becomes the norm to any percentage, one of the issues that has been there with our Supreme Court has been that there was always this lack of balance. You always heard complaints that it was always easier for litigants in Punjab and Haryana and Delhi to file special leave petitions. And that's why there was a demand for more benches. So if this becomes the norm, and if we eventually catch up with the capacity, then that imbalance will go. Those extra costs will go. The whole process of having to travel to Delhi to engage a Delhi-based lawyer, to have a separate advocate on record, to go through that entire process of listing, etc. If all of those things can be seamlessly moved into an online method system, then I think it's going to lead to more efficiency. But my view is, without sounding negative, I think we are a few months, if not a year or two, away from that.
Thank you.
Because there are a lot of teething troubles that still have to be taken care of.
Thank you so much, Arvind. Sham, let's quickly move to the sites of vulnerability, as I call it, in the sense that while this crisis obviously has affected and impacted so many different people, there are some populace, some sections are more vulnerable. So I want to raise one particular form of vulnerability. We'll go to the migrant issue a little later. Overpopulated Indian prisons with an occupancy level of over 100% are a site of vulnerability during the current corona crisis. With high levels of incarceration and temporary bails in the consideration to decongest the jails. I know that there have been orders no less than the Supreme Court of India. How do you think this will impact the outcome of a range of new cases and litigation that's going to come up in different courts? Should we be reimagine the framework of prisonization in our country?
Well, I mean, the short answer is that if the science that develops indicates that you are going to be at tremendous risk just by being in a very densely populated area such as a jail, I think it would be contrary to all principles to continue to incarcerate people who in a situation where, as you rightly mentioned, you could have COVID-19 spreading very, very easily. So I think the courts would be absolutely correct in directing release. I think this is the minimum human right. There's obviously a huge infrastructure deficit insofar as imprisonment and jails are concerned. So yes, over a period of time, it may also result in a different approach insofar as courts are concerned in directing and requiring prison and in sentencing. But I think we're really looking at the absolute near term. And in the near term, I don't think we should have a situation where prison populations are put at an enormous health risk only by virtue of the fact that our jails are very, very overcrowded. So I'm all in favor of release on terms and conditions, at least for a short period of time until the medical emergency sort of abates and better responses in terms of health come forth. Otherwise, I think it's a violation of human rights at a very basic level.
Thank you very much, Sham. Anu, let me ask you a question that's in the mind of many, particularly those who are in businesses, who are engaged in different forms of contract negotiations and the implications of it. So with worldwide emergency lockdowns disrupting the supply chain movement, commercial disputes will significantly occupy many aspects of litigation. With little or no uncertainty or certainty about the future, how long do you think force majeure clauses can protect organizations affected due to the pandemic? In some ways, the fundamental question is, will negotiation be the new litigation in many aspects of business?
I think that the limitation of force majeure clauses or contracts which don't have force majeure clauses and resorting to frustration under the Contract Act. A lot has been said on that. And the short answer to that is there are severe limitations to the extent to which force majeure can really protect businesses, primarily because of the fact that these clauses are extremely strictly interpreted. It depends on the text of the contract. They are typically extremely evidence heavy. And also, but most importantly, in a situation where we are addressing a pandemic, which may last for months together, whether force majeure would extend, the extent to which the duration of the force majeure would be assessed by the parties would certainly be subject to a dispute. The affected party, for instance, may want a long time of force majeure, whereas the counterparty may say that only the period of lockdown should be something that should be considered as force majeure. So this is something, you're absolutely right, is something which will end up entering into the litigation sphere, and cases have already come up, and we've had some kind of diverse views between high courts. Whether the Supreme Court comes in to set things right, that's a big question. Interestingly, aware that the finance ministry has actually said that anything which affects the supply for goods and services for contracts with the government, whether it is PPP or whether it's goods and services contract or any other kind of contracts where the government is a counterparty, there is a leeway of 3 to 6 months that parties can consider declaring force majeure with evidence, of course. But this sort of a leeway hasn't come for the other contracts, for private commercial contracts. Whether this will enter into negotiation, conciliation, mediation, I think it's inevitable, but perhaps not something which may necessarily yield a solution. And this is where I feel the question that you raised initially, Tushar, was the legal basis for the lockdown and legal basis for addressing the pandemic. Equally important is response measures to the pandemic. And this is where, again, there is a little bit of a contrast between India's approach and, say, what Singapore has done. To some extent, UK and a few other countries have done. India's approach is a little bit more fragmented. It's been coming in bits and spurts, and there is no comprehensive legislative framework to address it. I find Singapore's approach, of course, perhaps it's easier in a smaller country with lesser complexities. But what it did was to bring out a law, the COVID-19 temporary measures law, which actually talks about protecting Singapore citizens and enterprises from litigation if they can show that the performance of a contract can be attributed to the pandemic. There are various methods and systems that they have put in place in terms of assessing what would be material. The success of such a law, again, perhaps needs to be looked upon. But I think there is a lot of sense in giving clarity rather than leaving it to courts for specific fact situations to make an assessment. To have clarity in the form of a legislative framework on how such situations should be addressed would, I think, be a very important way forward.
Thank you very much, Anu. We are live on Facebook and YouTube. I invite the viewers to send in their questions. Shortly, we will be taking up those questions with our panelists as well. Purvi, I have a question which I think you are most suitable to answer. One of the things that has happened around the world is that governments have begun to enforce and assert a stronger sense of sovereignty and also become far more ambivalent when it comes to immigration. In fact, famously, the Australian Prime Minister talked about the fact that when it comes to for international students, he said that, you know what, thank you for being here. And now is the time for us to take care of our own people. And the similar sentiments have been expressed in different parts of the world. And of course, United States to some extent. So my question to you is that as an immigration lawyer, do you think that there are new type of challenges and cases that are going to come before you and firms like you in dealing with immigration as a phenomenon in both during and post-COVID context?
Absolutely, Raj. We see these problems on a daily basis. One of the biggest challenges that our Indian nationals were facing was that once India locked down, there were no flights to bring them in. And that really resulted in a major crisis. Even now, there are people out there who are not able to get back, though they want to, because of simple situations like this. They have a child born abroad. The child is not an Indian citizen. Indian visa services are closed. And they need a visa to come to India. So as a result, the mother and child both can't come. So we are facing such challenges. China has also, USA has also taken stringent measures against Chinese researchers and high-tech students. They have banned the visa issuance to this class of students. And they're also asking some of them to leave the country or revoking their visas. I'm fearful that our IT workers from India who are working in, let's say, sensitive projects or in government projects or in national security projects might face the same problem. But at the moment, we are friends with America, so maybe not. UK and Australia and all of them have given temporary measures. UK went proactively and extended their visas without any action required. America did no such thing. India has been fantastic. They have allowed all the expats working over here to stay on right up to June 30th without any problem, and they can file for online extensions, which are then approved online. So governments have handled it very differently, but definitely we are going to see a post-COVID turmoil in immigration. Germany is going to have a stringent law soon. France is making noises similarly. So we are going to see a post-COVID world, which is going to change. In fact, yesterday we were on a webinar with Dr. Shashi Tharoor and an economist, and we were discussing only this issue of the movement of people for work. And there was, I don't want to say consensus, but many people were of the view that jobs are going to move to people rather than people moving overseas or for work, just because of these issues which are going to increase.
Thank you very much, Purvi. And that is going to be a very compelling challenge for many, and your firms like yours will play a leadership role in that. Ritin, so one of the things that we can talk, and this is probably as good a time to talk about, is that to what extent we can address, use the COVID-19 as an opportunity for us to, let's say, do some fundamental reforms in our legal system. How do we use this opportunity to reimagine and address some of the critical challenges that we have been facing in our legal system? We know that we have over 30 million cases pending in our courts. Do you think artificial intelligence can, bringing in AI can help us address some of these backlogs in our system, or more and more technology may end up creating dividing the already pre-existing divisions that are in our society? Is to what extent use of technology in our country, with all the challenges that we face, can actually help solve disputes and even address some of the long-lasting problems of our legal system?
No, Raja, I mean, we have to use, what is the saying? You should not waste a crisis. We have to use this as an opportunity and do some substantial transformations of various of our courts. But the use of artificial intelligence is, of course, it has to be an ongoing project. I don't think there's going to be any short-term solutions with this. And equally, technology can be deployed only in certain courts initially, only within certain areas initially. I mean, you cannot have access to justice be dependent on access to technology. And so technology is going to be deployed, hopefully more in, let's say, my practice area, which is more commercial or regulatory disputes. I think we've already been seeing it being deployed over the last few years. And I think that trend will only accelerate. So I think that must be welcomed, embraced, and we must, try and use it as best as possible. I think in the few hearings, let's say, I've done in the last couple of months, I think it's very fair to say the High Court judges are enjoying the technology. They're very conversant with it. I think they're able to conduct a very good hearing, which is virtual. So I think we will continue to see technology being used more and more. But what I also think this pandemic has shown us, and it goes a little bit to what Anu said when you asked her the question about a force majeure, is that clarity in the law, both from the legislature as well as from judicial pronouncements, will again go a long way in cleaning up some of these issues. Anu gave you the example of the Singapore legislation, which is a very thought through legislation about the effect of COVID on industries or individuals and their contract law. We can contrast that, let's say, with our insolvency and bankruptcy code, where 2 months ago we were told this code will be suspended, and it took 2 months for the government to come up with an ordinance, which it finally promulgated just yesterday. And the ordinance is a one size fits all. It's just suspending the code in a blanket way for the next 6 months. I think those kinds of legislation which are not clear will again lead to more and more litigation. So I think as we face this challenge, artificial intelligence, use of technology are obviously going to be great assets, and we must deploy them. But there are also other things we should look at, which is just basic clarity in our legislation. And maybe I can add one more point, which is, as the legal community also struggles with work in this COVID environment, the judges can appoint commissioners to record evidence from the legal community. So I think we've got lots of resources here which we can deploy at this time, again, to address what has really been a problem with our legal system and gets accelerated or highlighted at a time like this.
Thank you very much, Ritin. Arvind, I think one of the things that we have not done so far effectively, at least from where I see, and you are part of the legal profession in a more closer manner, is that the growth and evolution of all forms of alternative dispute resolution, the full range, not just arbitration, but also mediation and conciliation and all of that. And I say that because of the fact that, how much of our capacity we try to increase and improve within the legal system in the form of courts, and we have a lot of work to do. There is a huge challenge of courts not clearing the matter. In fact, Mark Galanter, a very keen researcher on this, wrote several years ago that it's not that Indians are over litigious, just that it's not that there are too many cases out there. It's that things which go in don't come out, and there's absolute clogging within the system. And so long as you have that clogging within the system and other mechanisms are not created, you simply will be pursuing catching up game in that sense. So how do you think we can use this opportunity to develop a robust ADR system in India?
I think this, as Ritin said, we should never waste a crisis. So I think there is a slew of measures that can be taken. We'll also have to see what kind of interventions come from the authorities. For instance, the Insolvency and Bankruptcy Code was one example where act has come and it's suspended everything. But as far as ADR is concerned, I think it's safe to say that in a lot of commercial contracts and disputes, there used to be a conciliation clause, a mediation clause, and then an arbitration clause. And the mediation and conciliation clauses were never really given that much of importance. It was, if I can use the word, they were often mere formalities. So I think one development that we are going to see is that perhaps conciliation clauses will be taken more seriously before you get into the full gamut of adversarial arbitration. So that's one part which I think may come if the mindset changes. But with that, there is a note of caution that public memory is short. I think once the liquidity situation improves, once the immediate risk or the immediate danger recedes, then we may get to a point where people may say that, look, I want to be back in court, and I want some sort of finality from a formal court or a formal adjudication process. Where I think this is going to have a very positive effect is that we will see a lot of matters being referred to mediation. I think some commercial disputes will be increasingly referred to mediation. You will also find a very large percentage of family disputes, which actually form a very large percentage. The suits, the partition suits, and I'll also include matrimonial litigation in that. They form a very large percentage of judicial areas today in courts. And a lot of them, I think at least 25 to 30% of partition suits, family matters, a dispute between a father and son, or even a commercial dispute in companies being run by cousins, two groups of board of directors. I think you're going to find many more such matters that are going to be referred to mediation. And I think mediation will now be taken increasingly seriously by the parties. Sometimes what happens is, and I can tell you this, that a matter is referred to mediation, and the parties are very clear that they want a decision from the court, but they are advised by their lawyers, or that it's their own view that, look, let's not upset a judge. Let's do the round of the mediation center, so that nobody is able to say that we were not keen. So I think you're going to have a lot of matters referred to mediation. You're going to have probably more carefully drafted mediation and conciliation clauses in commercial contracts. So that's going to be a process which is going to be more formalized. And of course, criminal law. I think Mr. Devan had referred to something about our jails. I think, I'm not sure if we all know that 70% of our prisoner capacity today are actually under trials.
Yeah.
70%, as per the latest data, are under trials. So I don't see any reason why some of them, unless it's a heinous offense, why some of them should not be immediately released on bail. Even for economic offenses, there was a stipulation which said that for FIRs which deal for economic offenses which are less than 100 crores, look at granting bail. But if it's over 100 crores, but my point here is, even if it's over 100 crores and a charge sheet has been filed, an investigation is complete, why should a man be in a jail which is already 3 times the capacity?
Well, so I entirely agree with you, Arvind, and we all remember Justice Krishna Iyer's famous words, bail is a right and jail is an exception, and we really need to bring back that vision. Shyam, I want to ask a more fundamental question to you, because I know you've been working in the field of public law and human rights. During a crisis of this kind, governments tend to become stronger and assert their powers with the full force of law, and institutions tend to be more differential than what they are normally. That's the case with many institutions, and not just in India, but around the world. There is a natural sense that government is responding to a crisis, and both citizens and institutions need to galvanize a certain degree of social consciousness to be part of that. My question to you is that, do you feel that our courts have been far more timid than they should have been when it comes to responding to the migrant crisis in a more timely manner?
Well, it's a very difficult call, but I think, yeah, that's where I generally come out. Maybe they could have done a lot more.
Yes.
But you see, it's a very complex issue. When you raise something like the migrant crisis, I think a large number of high courts have responded. And there was difficulty in terms of access to justice, because in just approaching the courts, there was a problem. There's also a huge information deficit. So that's another kind of a problem. So I don't think it's fair to sort of tar all the courts and say that, look, they weren't responding, or that, in the general framework which you put it of timidity. I wouldn't call it that at all. I think there's a range of responses which you expect from judges and from courts. Look, our courts, for example, in the Supreme Court of India, we have over 30 justices. There are, high courts with dozens and dozens of justices. So I don't think it's a question of one court or the other. I think courts were definitely constrained because people were not able to approach it. When courts were approached, there was an initial response, which was that, look, or at least in the Supreme Court, that, look, let the government take care of this, or let the government respond. We don't want to enter into this area. And I think many of us would feel that that response was wanting. But I would still not attribute it to some larger construct of emergency and the courts in retreat and institutions in retreat. I think these very institutions have the personnel and the capacity to bounce back. And I think they have the strength of character, which is the institution itself, to require the government to answer where the government is found wanting. They will find a voice. It may take a little longer. Some of us might have felt that they should have found the voice a little earlier. But I am not giving up on our courts, because our courts have an outstanding track record of human rights jurisprudence. And I think we have the personnel who will deliver.
Thank you very much, Shyam. That's a very fair and balanced perspective. And I think it's important to say that, because courts are also working under extremely difficult circumstances as well. Anu, the question now for you is that, the current crisis may not only tilt the demand of legal services in a certain direction, such as emphasis on restructuring and insolvency, issues surrounding contract law. We talked about force majeure a bit, but will also require digitization of the law firm operations to ensure continuity of business. How are law firms like yours and maybe others adapting to this new demand of services and infusion of technology in their work? Are we metaphysically entering into a more personal space while working with colleagues, as it helps break certain rigidities of everyday hierarchies of working at a law firm?
Raj, I think again, there is no, one size fits all answer to that. I think we've been extremely grateful for technology to tide over this phase. As Purvi said, it was practically no interruption in services at all because of the fact that living in a metro city with decent bandwidth, except today, I think it's creating some trouble. But generally, it's been a fairly efficient experience. In terms of interaction with the firm members, however, I think there are pros and cons. At one level, the fact that everyone is connected and everyone is responsive to issues and matters that come up is certainly good. But I think law as a profession is really a profession for experiential learning, and a virtual situation is essentially a very isolationist kind of a world. However much we may rely on Zoom and WhatsApp chats and team interactions and all of that, I think it's really no long-term substitute for an office space, which can be far more vibrant in generating ideas and sharing of thoughts, picking up books and doing the research which firms like ours still encourage a lot more. So I think to a large extent, technology is an enabler. It can supplement, but it certainly cannot substitute the importance of physical space for lawyers getting together and figuring out solutions. Digitization is important, and I think a lot more firms, which are otherwise not equipped. I think the ones in the litigation sphere, I understand, were far more impacted for lack of completely being equipped with good Wi-Fi systems and all of that. So I think that's something which will perhaps need to be universalized a lot more, not just again limited to urban centers, but across the country. But overall, I think even for firms in cities like ours and doing largely transactional advisory work, it's really digitization is not a substitute. It can only supplement.
Thank you, Anu. We are live on Facebook and YouTube, and I have already received 100+ questions. So we will be getting into the Q&A session very shortly. Purvi, my question, it's building on the response that Anu said, and you can respond to the same question, but I want to also ask you that I believe your firm has been long prepared for these situations. So in some ways, do you think that from the standpoint of clients and interaction with this new situation, your better preparedness, to what extent it's going to help you, and what are the new changes that you see for the future?
So I definitely think that we were well prepared for this, though we had not planned to be prepared for COVID, but we turned out, we lucked out. But there are 2-3 things that we are going to change. In Mumbai, some of my staff travel 2 hours in each direction to get to our office. I'm definitely not letting them come back to office until July, because we've got a critical month in June where we do hundreds of filings in America. So they're not coming back for the next month for sure. After that, also, we are going to have them come in phases. Like we're going to do 3 days a week in office, or 2 days a week in office, 4 days at home, so that we don't miss out on what Anu said is the interpersonal interaction, ideas and growth. But we will definitely use this learning to ease their life a bit, because it's all about giving them a better life, quality of life. But one thing that has kept us going, and that is probably because we are a team of 16 and not 60 or 100 people, is we do Zoom meetings every day. At 11:30 we meet for 40 minutes, and at 4:30 we meet for 5 minutes. And that has been extremely helpful for all of us. In fact, some of them have learned to speak out and be more interactive and share their ideas, which they were reluctant to do in a physical space. Sitting in their own home gave them a little bit of anonymity, though we could see them, they were more willing to share. So our younger staff has become more confident. So I think we're going to tweak things to take advantage of our learnings.
Thank you very much, Purvi. Ritin, in some ways, building on what Purvi just said, now the current crisis has created a need for more empathy in dealing with cases that come our way. Do you think it will require and possibly promote a change in culture to have more compassion and emotional intelligence while dealing with cases? Will the current scenario require a new transition from the zero-sum mentality while managing even litigation to an ethos of, to a large extent, how do we achieve justice to all? To what extent will issues of, let's say, mental health and well-being of lawyers will become relevant for the future of law and litigation.
Raj, I'll just get to that, but I have to agree with both Purvi and Anu on, virtual interactions. I think they can really supplement, they can't substitute, but also just to pull a little bit from what Purvi and Anu also said, there is a very different interaction that takes place virtually. I think even in terms of our appearances before court, there's a little less formality in the engagement. And that may be also the judge giving you a bit of a longer rope because you're also trying to understand this virtual technology and interface. And so I think just as the judges are also being more accommodating of lawyers and recognizing the limitations of the presentation in court virtually, I think to your point, the lawyer community will also, it has also taken this pandemic on board and adjusted its relationships within the community. I think you're seeing, a lot of lawyers doing a lot of great public service work and trying to contribute. I think even with our clients, that will necessarily flow through, which will, as Arvind also said, I think lead to more mediated outcomes. I think you will see both in the short and the long term, an approach to try and reconcile a little bit more rather than to be more and more adversarial. In the short term, of course, this will be simply a matter also of budgets and wallets being tight, where companies will simply understand that they cannot litigate out a dispute and receive monies well into the future. So I think both plaintiff and defendant will find common ground more easily than they were in the past. And I think that I hope Arvind is not right that memory is short. I hope some of this will stay with the legal community. The experience we've had over the last 2 months, I think will inform us in future as well, where there will be, as you said, a lot more empathy, a lot more understanding of the person you're dealing with, and trying to, try and accommodate that as much as you can.
Thank you very much, Ritin. Arvind, there's one question which I've been thinking in terms of how we are learning from the past. Now, if you look at the previous economic crisis, such as the dot-com bubble burst or the stock market crash of 1987, it produced barely cosmetic changes and short-term industry bell-cinching in the legal field. They did not necessarily require rapid adoption of new operating models. How is this new economic crisis created by COVID-19 going to be different in the way it affects the legal profession? Do you see a greater place for alternative legal service providers, including LPOs, for example, in times you talked about ADR a bit before, because one of the major challenges will remain the cost that will be exorbitant to continue to use legal services as it was when particularly businesses are not doing well.
Raj, as far as alternate legal services providers are concerned and legal process outsourcing, I think you're definitely going to see a very positive growth as far as research is concerned. Adding to what Anu said about these LPOs, etc., being facilitators, I think you're going to see a lot of research shifting to these modules. You're also going to see perhaps some sort of increase in drafting by these alternate legal service providers. You're going to have more contracts in general formats. You're going to have a lot more research. And I think this kind of shift has to happen in every industry in every 20 years or so. You'll remember that when we started the legal profession, we all used to physically go to a library and research. In fact, that was one ritual. When I started going to the High Court or the Supreme Court, the first place we were all encouraged to go as young rookies was to please go to the library, familiarize yourself with the All India reporters, the SEC online, the Supreme Court case volumes, the labor volumes. And then 10 years later, it all shifted to, you got Manu Patra, you got SEC online, you got other search engines. So that's one change which happened. The other change which happened was even the way legal reporting used to happen has changed. Now you have a bar and bench, you have a live law, which very quickly and very instantly starts reporting what's happening in a courtroom. So I think every 10 years or every 20 years, there is bound to be some innovation. And I think this is only just accelerated that. So yes, I do see a lot of research-based work going to alternate legal service providers, to even LPOs and other companies, which may be run by young students, young lawyers who graduate out of law schools. But I don't think this is going to substitute the very fundamentals of law. I don't think you're going to be able to, as Anuradha said about experiential methods of learning, I don't think you're going to be able to sort of move the expertise which a partner in a commercial law firm brings to a merger or acquisition transaction to an LPO, or the expertise which somebody like Mr. Dewan will bring to to a constitutional issue which is being debated in the Supreme Court. So I think you're going to have a lot more interface, and then who knows, as their footprint increases in certain sections of the profession, it could actually lead to more. You're definitely going to see a lot more alternate legal service providers working in certain branches of law. For instance, data privacy is a prime example. You're going to, I think, a lot of IPR work, which was in any case, along with immigration, as Purvi said, which was very dependent on automated systems, is going to also shift to LPOs and legal service providers. But as far as the thick and thin is concerned of the court, or drafting a merger document or a demerger, I don't think that's going to shift, not just yet.
All right, thank you very much, Arvind. All right, we have 150 plus questions. I want to first thank the panelists to answer my questions. Now we'll pick up a few questions from, I have a question for Mr. Shyam Dewan. Shyam, this question is from Mollika Sridhar. Mollika is asking, since lockdown, whether any judgments pronounced by the Supreme Court and possibly high courts, which have been operationally implemented, will such judgments become good precedents in future when normalcy returns, and are there mechanisms to see the implementation of those judgments? Shyam.
Well, from what I understand of the question, have there been judgments which have been delivered during this period? The answer is yes. I know of several judgments which have been delivered by the Supreme Court of India. They've been pronounced, albeit in a virtual court setting, etc. So those are as effective as any other judgment which is pronounced in open court, in a physical court. So I think those will certainly be implemented. Those will certainly be enforced without any difficulty. I haven't seen, or at least in my limited experience, I haven't seen a full trial or a full hearing and a judgment beginning to end in a Supreme Court setting, though we do have many situations where the court has heard both parties and decided to dispose of a case. That happened in a matter which I did a few days ago, where you just had a very short hearing, the matter sort of bouncing back and forth between counsel on opposite sides, as well as with interactions of the court. And the court was quick to pronounce a final decision in the matter, altering the lower court's decision slightly. So that was a final judgment. It will be fully and completely implemented. So I don't think there's any difficulty with regard to the efficacy of the judgment. But the problem is that it's very few cases which the court has a capacity to handle for the present. So unless that is ramped up, and that in my experience is very improbable in the near term, you're going to have very few judgments which come out.
Thank you, Shyam. Purvi, there are lots of students who are watching this program as well. And several students, one of the dominant questions that they're asking is that to what extent the current crisis is going to shape the future of the legal profession itself. The opportunities that they might have in the future. Are there some areas of law which will become more dominant and more prominent? Should they be thinking about those areas as they think about law school studies?
So I mean, I always think that the legal profession has got thousands of opportunities, especially for people who are hardworking, use their smart brains, because if they've gotten into a law school, they're obviously smart to start with, but they've got to work on it, develop their smartness, and forge on. But yes, definitely looking for niche practice areas is a very good idea. I chose a niche practice area about 15 years ago, and I'm having fun. A lot of the largest law firms in India send me work because they know I'm not going to work on in their space. So finding a niche practice area is very good. There was a young student about 10 years ago whom I knew, who wrote just a few articles and did research on the law on gambling and online gaming. And now he has a very successful practice in this area. So I would say, guys, keep on top of things. Look at what is happening around the world. Yes, litigation will continue. Litigation is never going to go away as long as we are human beings. We're going to fight. But there are many ways in which you can even specialize within litigation. So I would suggest read a lot, be up to date with current affairs, and find a niche area, because a boutique practice might be more attractive to clients, because then the prices are lower, you are able to contain your costs, so you might have a better chance at building a larger practice if you're in a niche area.
Thank you very much, Purvi. That's very useful. Ritin, there are a number of questions from Sheetal and Asmat, Pradeep and Vijay and Stark. And the heart of the question is about to what extent some of the reforms that we're talking about, including reforming the ADR system, e-courts, e-adjudication, how much are these going to remain temporary measures, and somehow after we overcome this crisis, we go back to the previous not so good normal?
Yeah. I mean, I think this situation has already lasted, over 2 months and counting. It will last, unfortunately, a fair bit longer, and it will last long enough, I think, that the change won't just be transitory. I think we will imbibe some of these changes. And Raj, I think when you look at some of these changes that may come, I think it's not too unfair to say a lot of these changes were resisted also by the bar. And now I think the bar will find it harder to resist some of these changes, which make for a more efficient dispute resolution system. Once the change is adopted, and if it actually works, then I think you'll find it hard to go back to what used to be normal. Because if the new system is working, clients are appreciating it, and it is even enabling easier hearings or better hearings for judges, then I think it'll be hard to go back to the earlier regime. Let's talk about one issue which we haven't, for example, talked about so far, which is costs. And maybe now courts will insist on a more stringent system of costs, where frivolous petitions which are brought to court receive a harder sanction from court. And if we start implementing something like that, I think it'll be more lasting. So I think, like I said, I mean, this transition will go on for a while, and in that while, we will realize that there are more efficient ways of doing things. And if we actually see that they are more efficient, it will be quite hard to go back to business as usual, or as how things used to be.
Thank you very much. Anu, there's a very interesting question, and there are 3-4 questions which raises the issue of gender in the legal profession. We know that there are the number of judges in our higher courts and Supreme Court. Women are far lesser. Even the successful legal practitioners who happen to be women are even lesser. So the question that many of our viewers are asking is that, to what extent the current crisis, but also generally speaking, legal profession needs to focus on diversity and diversifying it, and particularly a stronger role for women?
Interesting question. I think, way back in from the 90s, when the law school started, Raj, I think it's been a uniform experience that students who've enrolled into the national law schools are 50% or sometimes higher percentage of women. And this is also translated into more number of women lawyers actually joining law firms and getting into litigation. But this perhaps hasn't translated sufficiently enough into representation at the judiciary. So I think overall, in terms of what steps need to be taken, it's really not something different from what is already being done, because gender is just too vast an issue, too much of a systemic issue. And at the heart of uh, the any kind of a real solution is more of systemic changes and more of awareness and all of that. But I think overall, at least from the time that I entered the legal profession, gender has never been a barrier. It's perhaps more difficult in certain types of lawyering when you are, because when you are a woman, but I don't think it's ever stopped women from doing well in whether in litigation or in law firms, or pursuing niche areas like Purvi setting up this fantastic boutique practice. So I think there are always encouraging examples that exist, which would perhaps be the motivational factors for aspiring women lawyers.
Thank you very much, Anu. Let me move. There's a question, Arvind, which you might answer. Several people are asking, Bhagyashri, Asmita, Sheetal, Sudhir, Jayashri, Anil, Trishant. These questions are all in relation to how should the legal system respond to the crisis in a manner which also takes into account the vulnerability of people. I mean, people are raising issues about, we talked about technology. Should there be a stronger investment in infrastructure in relation to improving the situation in courts? Because a lot of this news that emerges about virtual hearings and courts going into technology-based dispute settlement is confined to higher courts. So there are two others are asking specifically that how do you address these plethora of cases and people waiting for trials in the rural part of India? What are the urgent measures that need to be taken at the highest level so that we don't need to continuously wait for so long for justice at that level?
Raj, I think the answer to this is this actually highlights this unprecedented situation, highlights a concern which has been often highlighted by judges, retired judges, lawyers, the lack of pace at which legal infrastructure has been built up. And I think one of the reasons that has often been given has that specifically dealt with judicial vacancies, which did sort of pick up pace, has been that perhaps the government is is a big litigant. 60% or 70% of the times it's the government, whether it's the state government or the Union of India, which is a litigant. I think what we need to do is, along with healthcare, we have to very quickly, I think on a war footing, we have to improve infrastructure as far as the courts are concerned, as far as their facilities are concerned, because we are looking at Delhi, Mumbai, the Supreme Court, Chennai, Bangalore, where I think even with the stipulations of hearing all urgent matters, courts have perhaps worked at 25% of their capacity. Now you can imagine what the situation will be in every district court. And there are some very critical cases because I can't emphasize this enough, that the criticality of a case which is pending or which is filed does not depend on its stake or the parties. Everybody's litigation to that person or to that company is life changing. So I think for the district courts where actually our litigative system has its roots, we need to have infrastructure built up at a war footing, whether it's computers, whether it's new buildings, whether it's annexes. Internet connectivity is something else. That of course is a basic which has been exposed to us now. But the improvement in buildings, the improvement in chambers, libraries, the capacity, the number of judges we have per units of population, I think there has to be a huge improvement. And I'll give just two examples. I think recently, and these are examples from the capital city. Recently, there was a report where there was a report, I think 2 days back, that an 80-year-old had to file a petition in the Delhi High Court because he was being turned away from all hospitals. And he died before his case could be taken up. Now, notwithstanding the fact that the Delhi High Court has been extremely proactive, perhaps we need to have a system now in anticipation that if there is a future situation of a lockdown or a curfew, we will at least have facilities that at least some of our writ court benches will be there on a daily basis. Maybe if our writ courts were functioning, then perhaps the situation may not have arisen. Number one. Number two, India, India is a country where there is a lot of, it may sound a little morbid, but I just wanted to bring it to the notice of everybody, that we as a civilization, we as a people have attached a lot of ceremony to death, to how we, when it's Hindus, how we cremate our, and the ceremonies that happen, whether it's Muslims and Christians, their own burial ceremonies. So there is a lot of ceremony, there is a lot of social interface attached to the rights of people who have died and their families. I think this was also reported, one of our division benches of the Delhi High Court had to take suo motu notice of what was happening in this situation. So I think there are a lot of aspects where we need reforms on a war footing. I think healthcare is one, and the legal system is another, where we need many reforms and we need them very fast. And as Ritin said, perhaps as lawyers, we have to play our part, not be resistant to those reforms, not look at personal interest in the short run for every reform that happens, and just act as accelerators of those reforms.
Thank you very much, Arvind. Shyam, there's a question and several questions, one from Dhanbad, another from Mysore, Bhattacharya, Asmat Unisa, Yadunan Anand. They're all asking questions about what role can lawyers perform in relation to public leadership. How can they attach themselves to leading the efforts of some of the large-scale law reforms and institutional reforms that we talked about? Or in a sense, in fact, one of them is also mentioning about the Bar Association and the Bar Council situation, where can individual lawyers demonstrate leadership that go beyond the Bar Councils?
Well, definitely, I see an enormous role for bar associations over here. I think one of your early questions, for example, was with regard to whether we could be counted as exempted services or essential services at all. And I think in a sphere, in a field like that, while everything we do may not be an essential service, there is certainly certain areas of work which lawyers render service, which are essential all the time. And I think there is, as I see it, a role for bar associations to organize lawyers and ensure that we are at the forefront of providing those elements of essential service, even during a lockdown or even during a period when the extent of access to justice is very, very severely constrained. And I see a role for this both at the superior court levels, but also at the original levels, because that's where we probably require assistance. So yes, I think there is a huge leadership which can be played over there. I also think, so far at least, there has been, probably because everyone was sort of dazed by the enormity of the events and just felt pretty helpless. But I think the leadership, therefore, has to be now assumed, because it's gone on far too long. And members both of the bar as well as our courts and court administrators have to ensure that access to justice is restored at the earliest. This will mean examples being set not just by the Supreme Court of India, because the Supreme Court of India, as you know, has no administrative control over the other courts in the country, but it's really a crucial role in terms of access to justice, which is to be played by our high courts. And I see, therefore, a role both for our high courts and our bar associations attached to the high courts. Also, inevitably, the Supreme Court and the Supreme Court bar associations to play a leadership role in ensuring a swift return of access to justice. And there, at least the way I look at it in the near term, it's not going to be virtual courts by itself. possibly some sort of a hybrid system where we will have some limited physical courts functioning and some courts which are functioning on a virtual platform. But otherwise, resumption in terms of physical courts to me is necessary. As to when it happens and the graded manner in which it happens will be obviously an issue which will have to be thought through very carefully. But otherwise, for the vast majority of lawyers who are assisting in this process, I think they do not have the capacity to quickly access courts through this virtual links. So the courts don't have it, the infrastructure doesn't have it, the people who are at the forefront virtually of trying to get relief for the clients don't have that technology available to them. So I think reopening physical courts safely but quickly is, I think, imperative.
Thank you very much, Shyam. Anu, there's a very interesting question from Yadunand Anand. Yadunand is asking, I wish to know what is the way forward for lawyers to work closely with CS and CA? What efforts could be taken by institutes and Bar Council in this regard? With IBC law, there is need for more formal tie-ups in the Indian context. The foreign firms already have such tie-ups in Mumbai and Delhi. Please throw some light on it. I don't know whether you can answer the question, but
I can just share some thoughts. In terms of the discipline of CS or CAs and the role that they play in certain spheres of law have always existed. I think the question perhaps asks itself more to partnerships and the fact that multidisciplinary partnerships is not something that is allowed under Indian law. I'm not of the view that it's an essential aspect that needs to be addressed. Perhaps there are benefits to it. I really haven't applied my mind. But despite the fact that multidisciplinary partnerships do not exist, the fact that there is a need for cross-fertilization of disciplines and ideas and the role that the CS plays in any kind of corporate compliance works, for instance, is tremendous in terms of, I think the person asking the question already raised the issue of insolvency and that being an area where different expertise is really required, and the fact that several CA firms are also playing a critical role in that sphere. So again, there's no easy answer in terms of whether we need to move towards multidisciplinary partnerships. Perhaps it would be beneficial, but I don't think it's in itself, the absence of it, I don't think has necessarily been deterrent or
thank you very much. Purvi, there's a very interesting question from Abhilasha Ramakrishnan. Abhilasha is asking, while some big and mid-sized firms in India were able to quickly implement work from home policies and adapt to the situation, small firms and private practitioners were to a large extent unable to do so. As a result, many lawyers were laid off or not given salary during the lockdown period. What contingency measures should small firms / practitioners put in place to avoid such scenarios in the future, given that their resources may be limited?
So access to technology is not very expensive. I mean, for a little bit of money, you can actually have pretty sophisticated technology, which will allow you to quickly transition from work mode to work mode, like work from home or work from office. So I don't think that is a barrier at all. I think it's just the lack of vision. If these smaller firms had the vision that they should be going, using technology to increase efficiencies, just because technology creates efficiencies, not thinking of COVID, because none of us could do that, I think they would have been in a better place. Definitely, they would have been in a better place. And the advantage of technology, especially when we're doing repetitive work, even in creating simple things like a docket for the High Court, once you use technology, you've got templates which you can then, quickly modify or fill in to create more sophisticated documents. So entry barriers to technology are absolutely nominal. that's not an excuse. So yes, whoever has not started, whichever small firm has not started using technology should do so, and keep revenue streams balanced so that you're not stuck on only one client or two large clients for your revenue as a small firm. Make sure you have a broader client base, have individual clients as well. All that gives you agility.
Thank you very much, Purvi. Ritin, there is a question relating to, the relationship between law and technology, but not just in the areas of courtroom and digitization of the dispute resolution system, but more in relation to using technology and the implications for it when it comes to, the very process of, let's say, litigation, but also how do we transfer that to learning? This seems to be a question from a student where law students are tech savvy and are keen in participating actively in the digital transformation, but they need a facilitative and supporting environment in their early years of legal practice. Where do we start?
I think, to Purvi's point, it really, Raj, is about vision. I mean, we need as practitioners, even as younger law students or lawyers who are entering the profession, we need to constantly think about what the next few years will look like. And so, I can say it's a question I've been putting to interns who worked with me or younger lawyers who've joined me. Really, on day one, my question to them for the last 4 or 5 years has been, are you reading off a screen or do you need physical papers? And I tell them, in my office, please feel free to photocopy my file and read, your own set. But physically, it's going to be impossible at some point in time to collect all this paper. You're going to have to move towards using a screen, and using a screen for, Purvi mentioned templates, but some of my younger colleagues are able to pick up a point or a pleading much more quickly because they're searching a OCR file while, every one of us is dealing with physical paper. So really, I think the thought for every younger lawyer or law student should be, think very actively about how the profession is changing, how courtrooms are changing. Someone the other day asked me, how can I improve my advocacy in the context of these virtual hearings? And I said, of course, work on your advocacy, but also recognize that one thing courts have started insisting on more is now written submissions. So nothing to do with technology, but it's got to do with the future. It's got to do with how you will continuously be agile and relevant. And that question is not to be asked only by law students. It's to be asked by young lawyers, older lawyers, judges, every stakeholder. So technology, yes, but I think that the larger question is, how am I going to continue to be relevant to my client in future, and how can I best address that?
Thank you, Arvind. Thank you, Ritin. Arvind, there is lots of questions about trust in judiciary as an institution. And part of the aspect is that many have opinions about how judiciary seems to have handled many issues in recent past. But the heart of the question is that to what extent the trust of judiciary as an institution can be improved, not just during this time, but more generally.
I think, Raj, to start, issues of trust of judiciary perhaps have come in more due to innovations which have come in the way, as I said earlier, in the way you have proceedings in court being reported. They are being reported quite quickly, and sometimes my own view is, it's not as if I'm advocating any kind of censorship, but sometimes, earlier, if you look 10 years ago or 20 years ago, what was reported was a judgment or an order that was passed by the bench. Now, what is often reported is an exchange which actually doesn't form part of the judgment. There is often an exchange between a counsel and the bench, which is a method of getting to the crux of the matter. And some of these exchanges are reported, and there are perceptions that are formed, which I feel encourage people or groups to have some sort of buildup of prejudice that, X bench is a conservative bench, or this bench is a more relief-oriented bench, or this judge seems to be pro-liberal, this judge seems to be pro-state. I think my own view is that that happens because of a lot of interactions which are actually informal interactions, and which are happening because the judges know, and the counsels also know, that they are not going to form part of the judgment. Sometimes it's part of the human element of advocacy, that the bench is trying to understand and is also trying to see the belief of a counsel towards the cause that is being advocated. But having said that, I think something which you are doing, you're having you're ensuring that a lot of sitting judges as well as retired judges are interacting, because the judges, just like although the judges don't have service rules which prevent them from interacting with people, not necessarily the media, but just the citizenry at large. So they've always practiced self-restraint. But what you're doing, and what is now happening, increased interaction, is sort of demystifying the the institution as such, because an average lay person perhaps has not had opportunity to go to the Supreme Court or watch proceedings or try and understand the constraint or the work or the sheer work pressure under which the judges work, whether it's a Supreme Court, whether it's a trial court. I think as this interaction increases, the demystification happens, trust can only improve. Even now, I think there is a lot of trust. If you see comparatively institution to institution, there is a very high quality of interest that is there in the institution, and this can only improve as interaction improves. And I think that interaction is going to improve if this situation continues, and we have more time at hand, we have more interactions which are a little informal in nature, that trust is only going to improve.
Thank you very much, Arvind. Listen, I have 100 more questions unanswered, and as much as this is going very well, we need to stop. So I'm going to move to the last question for all the panelists here. Let me begin with Shyam. Shyam, along with that question, there are several questions which have come about. I'm going to add that question also to you. The question of privacy and the use of technology, to what extent it impacts privacy. Arogya Setu specifically have been asked as well by many people who are viewing. But that's one part of it which you should answer. But the main question I want to ask you is that for all those students of law, even faculty members of law, those who are broadly in law schools today who are watching this, what would you like to tell them as they experience this crisis along with their studies and research in law schools? With greater demands of justice created in times of this pandemic, what should they think about when they fashion their own future careers in law, and to what extent that will be impacted? This same question I will request all of you to answer. Begin with Shyam.
Well, there's a few points which I think strike me, and at a certain level, it's going to be, I'm going to draw on what others have already said. I think as you enter into the bar and the profession, I think it's a very tough period. I was thinking about this in the context of when I started and joined at the chamber of Firdaus Talia Khan in Mumbai several years ago, and he, the practice then was that you just sort of sat in chamber and waited for work. And that was the norm at that period. You never got paid. You sort of worked up on your senior's brief. And you had to have that little bit of staying power. Now, for those of us who were privileged and, we were being supported by our parents, even past law school, that was all right. But I can imagine that in many, many situations, you have young lawyers and young graduates who are about to enter the profession who are going to find that very difficult. But I think, number one, you're going to have a phase of 12 months, even longer possibly, where entering a chamber, joining a firm is going to be a very difficult and tall ask. So the first thing is that you're going to have to believe in yourself and stick around. The second thing, and here I concur with what Ritin mentioned, which is essentially you're going to need a set of skills which some of us may not have required, but which you are going to require in large measure. And one of the important sets of skills is going to be writing well, persuading people, which is, for those of you in litigation, through the written word. Because I think inevitably with with the extent of the number of cases we have, I think oral advocacy is going to shrink at least your appellate court levels, etc. So I would again urge or reinforce that build your skills, including your writing skills, because that's, I think, where the future lies.
Thank you very much, Shyam. Anuradha.
I think just to, I completely concur with what Shyam just explained in terms of the importance of resilience and to just wait through this period. But at the same time, to productively utilize this period, writing is an excellent example. Also expanding knowledge. There are, I think, a surfeit of courses, online courses on a variety of interesting areas. Specialization in IT-related aspects and IPR-related aspects, technology law. I think there is a lot of that which can be pursued to add on to the skills of lawyering during this period. At the same time, I keep getting applications for virtual internships, and I think most firms would actually be amenable to that, so to capitalize and utilize that to the extent possible. Also, there's a very interesting book that I read recently called Range. It's by an author called David Epstein, who really talks about the fact that while specialization is important and while specialization is beneficial, there is a lot to be said for generalists. So because there's really no end to knowledge, and that too in the legal sphere. So to the extent that you can expand your knowledge on any interesting area of law and equip yourself, it's going to come into play at some point of time.
Thank you very much, Anu. Purvi.
I'm going to address the women lawyers, the budding women lawyers, because I'm very passionate about them being in the workforce. Like Anu mentioned, more than 50-60% join the colleges, they join the entry-level jobs, but they don't stick around. So I want to tell you, young girls out there, that biology is not going to change, but mindsets have changed. Growing up, I always believed that I had two jobs and I had to do two jobs. One from which I could resign and one from which I could never resign. And that was being wife, homemaker, and mother. However, now you women are so lucky because the men are taking an active role in raising children, in contributing to the house, etc. So make a fantastic relationship with your life partner and make sure that you're able to grow with him in his career. There are 2-3 things I also want to say. Anu mentioned online courses. I want to give you specifics. There are fantastic online platforms like Coursera, LinkedIn University, and many more like that. There are specialized courses run by the American Bar Association, the International Bar Association, or niche practices which you can avail of. If anyone wants to even take courses in immigration, there are special courses available online. All this is online, so you can sit at home. And also in the international market, there is a concept of micro-certification. So let's say you only do 50 credits, 50 hours of study on copyright, you could still get certified, and then copyrights would then help you improve your chances of getting a job after the 12-month period that Shyam said you might have a dip in job availability. So I would say spend time and money on micro-certification. And the last thing, be kind to yourself. Like I said, biology is not going to change. So it's okay to take sabbaticals. I took 2 long ones, but I went back to study when I was 42. I went back to the University of Pennsylvania, got certified in New York, and I was kind to myself. I had a kind husband too, but you can survive and you can reach the top.
Fascinating, Purvi. Deeply inspiring. I just want to add, when it comes to online courses, the Jindal Global Law School has just launched the 1-year LLM in corporate and financial law, entirely online, first and only LLM program in India. We're doing the formal launch on 13th with Haigreev Khaitan, Pallavi Shroff, Ronnie Screwvala, and a judge from the Supreme Court of New York, Justice Cooper, as well as Falgun. All of us will be back on 13th, and I invite you to join that launch as well. Please, I think it was written, yeah.
No, really, Raj, when you assemble Sham Devan and Purvi and Anuradha, there's not much more I can add to what they've already said. I mean, I can only really agree. I think, but just to say what Purvi was saying, be kind to yourself. I mean, to all the young law students, this is an incredibly hard time to be graduating or to be joining the profession. And I think be kind to yourself. Don't be too harsh on yourself. You all are not the only ones facing this challenge. I think everybody is facing the challenge, but obviously it's hitting you in a far more different way than it may be hitting somebody who's started out on their career or is more experienced in their career. I think Purvi also made another important point, which is she said, find a life partner. I would say more generally, enjoy some of this leisure time, read widely, history, philosophy, literature. Don't necessarily only do online courses. Even Jindal's online course, don't only do that, but read more widely. It will stand you in good stead over time. And again, this COVID pandemic is unprecedented. But as you join the profession, as you graduate from law school, I mean, stay committed to what brought you in there. Stay passionate about what you do. Stay committed to it, as Sham said. Be patient about it. This too shall pass. And again, I think I can recognize it. It would be enormously difficult if I was in my final year of law school or even in law school at a time like this. It's not easy at all. But I think some of these life lessons that Sham or Anu and Purvi have spoken about, take them seriously because they will stand you in good stead.
Please, Arvind.
I think most has been said. I'll just add that along with kindness and reading, just cliche as it may sound, just be very positive and maintain your optimism. This too shall pass, and believe in the resilience of mankind. We recovered from the world wars. We recovered from natural disasters. We recovered from tsunamis and earthquakes, and I'm sure this will pass. And I think this leisure time perhaps may not return once, maybe 6 months, 12 months, 18 months, 24 months, once we have a vaccine, once we have an entire treatment protocol, we go back to the older systems. Perhaps some of us may end up saying that we could have better utilized this leisure time. So a lot of we can read, and as Ritin said, there really is no need for it to be restricted to law. There are so many other elements to that reading. And even within law, there are, even if somebody is interested in IPR, no harm in reading a little bit about public international law, no harm in reading about what Purvi is doing with the way borders are closing. You never know how situations change, which branch of law becomes more lucrative. I think that's about it. Eventually, optimism and positivity.
Thank you very much, Arvind. Well, thank you to all of you. All of you panelists have been absolutely amazing. I couldn't have got a better group of people with so much of experience, passion, commitment, dedication, and in many ways, an effort to inspire many people who have been watching this. I want to thank you for taking the time out. By way of full and complete disclosure, one of the remarkable things about that I do as an academic is to bring a lot of busy lawyers and don't pay them anything to talk about the future of law and justice. And this group has been absolutely kind, and I'm really, really grateful to each one of you. I want to thank our viewers for sending in so many questions. I apologize that I couldn't take up those 100+ questions, which are still coming. And keep tuning in, and we will have many more such colloquiums. I want to thank our knowledge partner, Live Law, for also promoting this initiative. This has been a part of a public interest initiative promoted by Jindal Global Law School and OP Jindal Global University. I want to thank all of you for being part of this. We will be back again on Wednesday, the 10th June, on what I call the Indian Judicial Colloquium on the theme Delivering Justice in Difficult Times, the role of courts and judges. We have 5 distinguished sitting judges of high courts: Honorable Mr. Justice Sanjeev Banerjee, Judge of the Calcutta High Court; Honorable Dr. Justice Vineet Kothari, Judge of the Madras High Court; Honorable Ms. Justice Geeta Mittal, Chief Justice of the High Court of Jammu and Kashmir, Honorable Mr. Justice A.K. Jayashankaran Nambiar, Judge of the High Court of Kerala, Honorable Mr. Justice Apresh Kumar Singh, Judge of the High Court of Jharkhand. We'll be back on Wednesday, 10th June at 6:30 p.m. to discuss this. With those words, once again, I would like to thank each one of you for your presence. I deeply appreciate it.
Thank you, Raj.
Thank you very much.
Thanks
Thank
a lot.
you.
Thank you.